you'll go down in history. Here we go. Welcome to the afternoon session of the Kansas Court of Appeals. We're glad you're here in what Judge Bruns a minute ago called our new normal. We will probably be doing oral arguments through the balance of this year by Zoom. And there are some benefits. I mean, it saves some money because attorneys don't have to travel so far, and it allows for many more people to see what we do every day because this will be archived on our website. It's also being closed captioned, so we're getting a little more transparency than we've had in the past. So if the parties, I'm calling the case of Bucklin National Bank versus Hayse Ranch et al. If the parties would state their appearances, please.
Your Honor, Martin Ufford on behalf of the plaintiff appellee, Bucklin National Bank.
Okay.
May it please the court, Your Honor, Josh Nicolay appears on behalf of appellant intervenor Celia Pruitt.
Okay. And I should have introduced the panel. I'm sorry, I forgot to do that. I'm Judge Karen Arnoldberger. I'm the Chief Judge of the Kansas Court of Appeals. To my right is Judge David Bruns, and to my left, Judge Kim Schroeder. Judge Schroeder was a trial court judge down in Hugoton area. What was the county? What were the counties, Judge Schroeder?
Stewart, Haskell, Morton, Grant, and Stanton.
Okay, and Judge Bruns was in Shawnee County, and I was in Overland Park.
I couldn't cover all those additional counties. We only
right, he's way superior.
We were at a circuit.
Yeah.
Not the course.
Right. Okay, so Mr. Ufford, or excuse me, Mr. Nicolay, do you wish to reserve any time for rebuttal?
Yes, Your Honor, I'd like to reserve 5 minutes, please.
Okay, so 10 and 5. And you can begin when, well, let me back up just a little bit. Generally, we've read the briefs, we've read a lot of the record in this case. And so I generally tell people don't go into the facts, we know the facts. But I'll give you about 2 minutes extra time if you want to just say the facts first. So if anybody's watching this now or in the future, they'll understand what this case is about.
Okay, I would like to have an opportunity to do that, Your Honor.
Okay,
thank you. This case actually, the facts involved start back in a 2002 foreclosure action that occurred in Kiowa County, wherein our client, Celia Pruitt, was assigned the statutory right of redemption from a landowner who owned a quarter section of ground in Kiowa. The property went to foreclosure sale. Our client was assigned the right of redemption. The assignment was filed within the foreclosure action. Our client then effected a redemption of the property by tendering the funds into the court and then filing a notice of exercise of right of redemption. Subsequent to that foreclosure action, our client then caused to be filed an affidavit in 2007, wherein her attorney of record at the time, and this was filed of record in the Kiowa County Register of Deeds, and it was indexed to the subject property at issue here. And the affidavit directed and provided notice of the foreclosure action and specifically stated that the appellant became the owner of the subject property by virtue of her acquisition of rights of redemption. And it further stated that all persons dealing with the subject property should take due notice that the appellant is the lawful owner of the subject property. In 2015, one of the named defendants, Helen Hayse, granted a mortgage on the subject property to the appellee plaintiff, Bucklin National Bank. In 2018, Bucklin Bank filed a foreclosure suit. In this foreclosure suit, our client was not named as a party, was not provided service. She did file a pro se motion to intervene and request for an answer. The bank filed a motion for summary judgment seeking a determination that the appellant did not have any interest in the property, that district court granted that motion, determining that she did not have any interest in the property due to the fact that there was no a pertinent deed that was executed alongside the assignment of right of redemption, and that the exercise of the right of redemption did not affect a vesting of title in the appellant. Appellant then filed a couple of different motions to post-trial motions, which were also denied. And so where we're at here today is the result of the judgment. Well, Your Honor, I mean, I guess from our standpoint, this matter really kind of gets to the heart of what the statutory right of redemption is here in the state of Kansas. It's defined it's created by KSA 60-2414, and the statute provides that a defendant owner may redeem any property sold under execution within a certain amount of time by paying the amount paid by the holder of the certificate of purchase. Since that statute was enacted, there's been ample amount of case law surrounding that. I would specifically direct the court to Southwest State Bank v. Quinn, 198 Can 359, which just generally states that the statutory right of redemption is a right of a debtor to regain property which it lost through judicial foreclosure sale. The court makes it specifically states that, this is a valuable right that a landowner has in owning a piece of property, and it's assignable under 60-2414.
What is to gain, counsel? What does someone gain? What does your client gain by paying $100 for these redemption rights rather than buying it on the courthouse steps? Or
well, if the amount due and owing for the property and what it's sold for at foreclosure sale is less than the fair market value of the property, then they stand to gain, assuming that the right of redemption vests her with the ability to gain title. It would give her the ability to acquire the property for less than what the market value was, but in the same manner that the original fee owner would have had.
in this particular case, I didn't see it in the record anywhere, and it's probably not pertinent one way or the other, but was Miss Pruitt, did she know these people, or is this just she's in the business of acquiring property?
It's not in the record, Your Honor, and this was all a little bit before my time, but my understanding of it is Miss Pruitt is from the area. She does have real property interests, not immediately adjacent to this property, but she knew of this family. The son actually reached out to her asking if they could help. He wanted to financial property. Yeah, they were in financial hardship. He wanted to continue farming the property and wanted to find somebody who'd be able to acquire it and then would allow him to continue farming.
Okay, thank you.
Question.
Yes.
Do you know why there was not a formal quitclaim deed prepared after she exercised her right of redemption?
No, I don't. Again, Your Honor, this was before my time. My partner.
I understand it was before your time. I just didn't know if the record reflected in the history of the parties any reason for that.
I don't believe the record of the 2002 case states as such. I don't think it specifically finds one way or the other. I mean, if I were to make an assumption here, my belief would be that they followed title standards, and Title Standard 1510 provides two different mechanisms for an assignee to basically acquire title. One is through quitclaim deed. The other is through filing a notice of the assignment of right of redemption in the foreclosure action itself. And so the second option was what was chose there.
Council, let's talk a little bit about the law then that relates to that, and you can educate us some. First of all, do you know any authority either in Kansas or in other jurisdiction that would stand for the proposition that redeeming property is the equivalent of conveyance of legal ownership of property? Or would this be the first case?
I know of no authority in the state of Kansas, Your Honor.
What about other states then?
The in the motion for summary judgment, a case was cited to there. I believe it was a Washington case was cited where it was a kind of similar situation where the Washington State Court basically said, because we have a strict requirement that conveyances only occur by virtue of a notarized deed, a mere assignment of a right of redemption through just a normal assignment document in and of itself isn't going to affect a transfer of real property rights. My understanding of the Washington State statutory right of redemption, however, does not provide an explicit subsection for the assignment of rights of redemption. And so I think that
well, whether it does or doesn't, that's a different question, because I'm talking about legal ownership now, and you don't know of any cases out there, either Kansas or other jurisdictions. So this would be the first one, it sounds like. As far as you know.
As far as I know, yes, Your Honor.
Okay, so in a normal situation with redemption, if you foreclose on my house, I own the right of redemption, but I also own legal title to the property. How did the legal title to the property get exchanged here?
Well, and I guess if I could, and maybe, I guess if I could hearken to the law school bundle of sticks analogy that's often used.
Okay, how'd they get back? Okay, Professor Duncan or whoever you had, where'd you go to law school?
I had Professor Pierce.
Okay, Pierce, Professor Pierce just retired, I understand. So he's divided the fee simple bundles of sticks into two. So now one person owns redemption, the other owns the legal title. How do we get that bundle of sticks back together then?
Well, I guess as I understand the bundle of sticks analogy, I
never thought I'd use this in real life. Thank you. I'm glad we are.
The legal title stick would actually be held by the holder of the certificate of purchase. The foreclosure sale has already occurred, and so legal title has transferred to the holder of certificate of purchase. Me being the prior owner.
Who is who in this case then? Who owns the certificate of purchase?
The certificate of purchase, I don't know. I believe it was I think it was the foreclosing bank.
But clearly it's somebody besides your client. So we still have, the bundle is not united yet. What document unites that bundle?
I would say that the right of redemption itself it's a stick that you hold in the bundle, and that is the stick that you use to reacquire the balance of the bundle.
And does that comply with the statute of frauds in KSA 58-2201 at SEC or not? Do we have a statute of frauds problem here for conveying legal title of property?
Correct, and this was it was a written document. It was signed and notarized. I believe the statute of frauds says that conveyance of real property may be affected by deed. I don't think it requires it.
But it does require a writing signed by the parties.
Correct, and this was a writing, and it was signed by Helen Hayse.
And was it notarized?
The assignment of right of redemption was notarized, Your Honor.
No, I'm talking about when she actually redeemed the property.
The redemption itself?
Because that would have been the conveyance. Just me taking an assignment of redemption rights certainly doesn't give me legal title. What may give me legal title is if I actually redeem the property. Correct or incorrect?
Well, yes, the action of redeeming the property is what, that's the position we take, is the action itself of redeeming the property is what vests title.
It was hers.
And so is there a document signed by both the legal owner of the property at that time and your client, and complies with whatever we need to on the statute of frauds.
There is a notice of exercise of right of redemption that's signed by our client's attorney and filed in the foreclosure action. I believe, though, that 602414 itself lays out how the notice of right of redemption is supposed to be effected.
Well, maybe I'm mistaken, but if here there's no sheriff's sale, so she just went into the clerk and paid,
There was a
correct?
sheriff's sale initially. There was
Well,
an
there was initial. We're talking after the initial sheriff's sale. She
Correct.
goes then and redeems the property. Who'd she pay the money to?
She paid it into the district court.
And what did the district court give her to signify that she had redeemed the property and now was the legal owner, as you claim?
The district court didn't issue anything.
So what, you know, in a sheriff's sale, the sheriff would give me a deed. Here, she doesn't have anything to actually show legal ownership.
Other than the assignment of the right of redemption that was signed and notarized by the holder of the right of redemption.
But how's an assignment? I could take all the assignments of redemption in the world, unless I exercise those rights and have something. How does that possibly? I'm struggling with how does that jump? It seems like a leap here to now say it's legal ownership, simply because you took an assignment of redemption rights.
Well, could I possibly answer your question with another question?
You can, but I may not answer it.
I guess the question I would have is, if that's the case, we have a specific subparagraph of 602414 that contemplates and provides for how rights of redemption are assigned by a holder to a third party. Upon that assignment, if it's done pursuant to the statute, what does the assignee then have at that point?
It's a good question. It seems like at least an equitable interest, and she should have been named in this foreclosure suit, but she intervened, so she got into it. Wouldn't you still need a quiet title action or something to establish that she is the owner of this property? Or do we just automatically assume that anybody that ever takes an assignment of redemption is the legal title holder of the property?
Well, I don't think I think the assignment of redemption is one step there. Then they have to exercise it by paying the money into the court to make the certificate.
So what do they get in return? You said nothing.
Well, that's correct. I mean, if the fee title holder, though, exercises their right of redemption, the statute doesn't provide that they're required to get a deed back from the court.
Of course not, because they already owned the property.
But don't they?
They're already the legal owner of the property pending the expiration of the redemption period.
But the owner, hasn't the owner, through the exercise of assigning the redemption, relinquished their rights of ownership to the redeemer, to who the assignee?
And Judge Schroeder, I guess that would be our position. I mean, at the time that the assignment of right of redemption occurred, the foreclosure sale had already gone through. We were just waiting for the clock to run down before the sheriff's deed would be executed. And so it's our position that at the time that the right of redemption was assigned by Helen Hayse to our client, that was the only thing that Helen Hayse actually had insofar as rights to this property were concerned. I mean, she certainly couldn't have executed a warranty deed. She had lost title to it. She'd be in breach of the warranty the moment that she executed the deed.
Who could have at that point then? The sheriff, I take it.
Perhaps.
The sheriff's deed's not a warranty deed.
And it's not a warranty deed.
Well,
yes.
I mean, any deed. I don't care if it's a quitclaim deed. Matter of fact, a quitclaim deed we wouldn't be here if there had been one.
Well,
but
All right, I've let you go way over.
I have one other question.
Well, it's because Judge Schroeder and I were debating.
Yes, I can tell that.
Well, but isn't the confirmation of her redemption the notice that's filed in the foreclosure action in 2002 that confirms that the redemption has taken place?
I mean, I believe so. Yeah, there's a notice and there's also a journal entry that specifically referenced that the redemption has occurred. It doesn't state that it doesn't state that title is specifically quieted insofar as our client's claim is concerned, but There's the notice that is filed in the foreclosure action, which is what's required of the title standards. And there's also a journal entry confirming it.
Thank you.
You're talking about the provision in the notice of exercise of right of redemption that says all should take notice that Celia Pruitt is now owner of legal title to the above described real property.
Correct, Your Honor.
Okay, I'll still give you your time in rebuttal, and Mr. Efford, I'll give you a little extra time too. Go ahead.
Thank you, Your Honor. May I have a 2-minute warning, however, please?
Oh, yeah.
Okay, just in case. All right, thank you very much. Your Honors, this is a case of first impression in the state of Kansas. No Kansas appellate court opinion has adopted intervener Pruitt's argument that the mere exercise of a right of redemption by a mortgagor's assignee without an accompanying deed of conveyance from the mortgagor operates to convey the mortgagor's fee title to the assignee. Since we are dealing with a summary judgment ruling, there are, I believe, 4 facts that are not in dispute in this case. First, Helen Hayse did assign her rights of redemption in the 2002 foreclosure case back in 2003. The assignment of rights of redemption from Hayse to Pruitt provides in pertinent part, the undersigned does hereby sell, assign, and transfer to Celia Pruitt all of Helen Hayes' redemption rights in and to the following described property. Pruitt timely exercised the right of redemption and filed a notice of exercise of right of redemption on August 1, 2003, which, by the way, is not a notarized document. Pruitt did not receive a deed or other document of conveyance of the fee estate at the time Hayes assigned her redemption rights to Pruitt. And from 31 days after this foreclosure action was filed up to the present, Pruitt has been permitted to participate in this lawsuit, make any argument she and her attorney have desired to make, and have presented any evidence they believe supports their position. So, turning first to what is the right of redemption, I agree with counsel.
Mr. Efford, I have a question.
Yes, Your Honor.
All right. So at the time Mrs. Hayes signed the redemption to Mrs. Pruitt, she no longer was the fee owner of the property, was she?
Your Honor, yes, she was. I believe she was. And the reason why
wasn't the fee ownership transferred to the person who bought the property at sheriff's sale?
No, Your Honor.
The right of redemption?
No, Your Honor. The only thing that was assigned to Ms. Pruitt was the right of redemption. Then we get to the exercise of the right of redemption.
At the time she signed the right of redemption, she had lost title to the property and only had the right to sign to exercise redemption, because property was held by the certificate of purchase, was it not?
The feasible title was held by the person who held the certificate of purchase.
So all she had the right to do was sign the power of redemption.
Well, she also had other rights that were conveyed to her, I'm assuming by some sort of deed. I'm assuming she had fee title absolute, which gave her a bundle of rights like we've been talking about.
But that's before the foreclosure was the foreclosure sale. Once the foreclosure sale took place, title transferred to the certificate holder of purchase.
Your Honor, I would say there is a bulk of case law from other jurisdictions, which I respectfully submit hold otherwise. And I think to address one of the questions that was asked counsel during his argument, the appellee cites no authority whatsoever to support the claim that upon the assignee's exercise of the right of redemption, the assignee becomes the fee owner of the property. In contrast, the concept of redemption has had a fairly unique meaning for more than 100 years throughout the United States. And we have cited authorities in our brief. On pages 14, we cite Thompson on Real Property, which specifically refutes the argument that counsel is making. That treatise says the effective redemption by one obligated to pay the debt or in privity with that person is to satisfy the debt and remove the lien. The redemption will cancel the sale and leave title in the owner. No new title is created by redemption, but the mortgagor's title is merely revived. Redemption by a mortgagor's grantee from foreclosure sale within the statutory period terminates any further proceedings to enforce the decree and defeats the inchoate title of the purchaser. An even broader, more recognized authority is 47 Amjur 2nd Judicial Sales at section 215 that we also quote on page 14 of our brief, that reaches the same conclusion, stating redemption of property sold under a judicial sale by the judgment debtor or its successor restores the property to the same condition as if no sale had been attempted. What's the same condition? Title in the mortgagor. We also quote the 19...
Before you go, wait a second. Before you go, you read an awful lot of stuff here. I want to make sure I understand what your argument is based on all this stuff you're reading. It's your argument, I take it from reading between the lines, that you're saying that once Pruitt went in and redeemed the property, that the legal title reverted back to Hayse. Is that what you're saying?
That's exactly what these authorities I've been citing state, Your Honor. And also...
And then Hayse could have deeded the property over to Pruitt, is what you're saying. Or they could have fought about in a quiet title action or something over who owned the property.
What would be the point of somebody acquiring someone's rights of redemption? The statute says you can assign your rights of redemption. So that must mean something. That must have some value too, to the person that they're assigned to. What value does that have?
Yes, Your Honor. During the period of the right of redemption, the holder of the redemption rights has the rights to the rents and profits of the property. And so, for example, if we have farmland that's been foreclosed and the farmer who owns the property doesn't have the financial means to actually harvest the crop that will ripen during the redemption period, I could buy the right of redemption from that farmer for a fairly nominal sum. I could then harvest the crops, reap a profit from the crop, and not go the additional step further of actually paying the price that was paid at the foreclosure sale. I could still make some money. Also, we talk in our brief.
But you've paid a lot of money. You paid the whole value of the, in this case, you paid the whole value of the property.
But what I'm saying, Your Honor, is a lot of times people buy redemption rights for a fairly nominal sum. And as long as you have the right of redemption, you have the right to the rent and profits through the redemption period. And also, we cite the bankruptcy case in our brief, where the bankruptcy courts permit bankruptcy trustees to sell just the redemption rights as opposed to the fee title to everything to third parties. Now, why would someone want to buy just the redemption rights at a bankruptcy trustee sale? Well, there are two reasons. One is there's the opportunity I just mentioned to reap some money from the harvesting of crops, but also first mortgage holders themselves buy redemption rights in bankruptcy trustee sales. For example, in the bankruptcy case we cite, stay relief had been granted, a foreclosure action had been filed, and a week before the sheriff's sale, there was a bankruptcy sale of the redemption rights, which then permitted the first mortgage holder to immediately get a sheriff's deed upon confirmation of the sale, as opposed to writing out whatever the redemption period was, which I think further demonstrates that the transfer of redemption rights is just part of what lies in the real estate and not the entire fee estate.
Thank you.
Okay, well, your client, I assume, when they took this mortgage, had title work done?
Your Honor, I'm assuming they did. I don't think that's in the record. And I have to state that I was hired just to handle the appeal. I was not trial counsel. So I am just bound by whatever's in the record that you all have.
So you don't know anything about the title work that was done or the title for the bank and taking the mortgage?
Right, but I can speak from 40 plus years of experience representing banks that if the bank doesn't believe it has a first mortgage lien or whatever priority it thought it had when it took the mortgage based upon title evidence, it's not going to make the loan. That's
well. So tell me.
Well, they believed it.
Pardon me?
Go ahead, Judge Schroeder.
Well, tell me what the notice in the original foreclosure in 2002 that said she redeemed it and was now the owner of the property. and also the affidavit by Mr. Stoll that was in the Register of Deeds office, what
Well,
kind
Your
of
Honor,
notice
I
did
think
that
first of all, those could arguably just self-serving statements by whoever prepared the notice of redemption or Mr. Stoll's affidavit, which by the way was filed 3 or 4 years after the fact. In contrast,
but 7 or 8 years before your client took a mortgage?
that is correct. And whether or not that imparted notice or not and should have been picked up by a title report as to name someone who ought to be named in the foreclosure action, clear title, is a different question than does the affidavit or the notice of redemption effectively convey the fee title to the assignee. And I would also point out that, for example, the will statute, KSA 59-614, provides every devise of real estate shall pass all the estate of the testator therein, unless it clearly appears by the will that he or she intended to pass a lesser estate. And also the divorce statute, talking about divorce decrees, provides a decree under KSA 23-2711 shall divide the real and personal property of the parties. Now, unlike the statutes pertaining to wills and divorce decrees, those statutes ultimately require a court order, a journal entry of final settlement, or a journal of divorce signed by a judge that effectuates the transfer of title either by the will or the divorce decree. In contrast, the notice of the exercise of right of redemption is not a court order. It is not signed by a judge. And I'm sorry, but I could not find any journal entry in this case where any court approved the filing of the notice of the exercise of right of redemption. I just quickly looked at the index on the record. I may be mistaken, but I didn't see anything like that.
But the prior mortgage, that was Bucklin as well, wasn't it?
Let me see.
Maybe not. I thought.
I'm not sure which bank it was, Your Honor. The
All
caption
right.
of the case is in there.
Anything else you'd like to add? Any questions? I've let you go.
Well, a question just on what you just said. Are you saying that a district court needs to give approval for the filing of the notice that the property's been redeemed?
No, the statute doesn't require an approval of the filing of the notice, but the argument was the filing of the notice effectuate the transfer of title. And what I'm saying is, unlike the divorce and probate statutes pertaining to probating wills, there's nothing in here that we have a judicial finding that Ms. Pruitt is the owner of the property as suggested by the notice of the exercise of the right of redemption.
So your argument is that it reverted back, that once Pruitt redeemed, the ownership reverted back to Hayse. And at that point, if Pruitt wanted the property, she needed to work it out with Hayse. Is that what you're saying?
That is correct, Your Honor, based upon essentially how the term right of redemption and the effect of that right of redemption has been construed by other courts throughout the country that have directly addressed this issue.
Okay, what would you please tell me the will statute you were referring to?
Yes, Your Honor.
Statute number?
Yes. The will statute is KSA 59-614.
Okay. Where's my 59-614? Okay, thank you.
And that's the one that says every devise of real estate shall pass all the estate unless it clearly appears by the will that she intended a lesser estate to pass.
Okay. And what is your, I have one more question. What is your position on the Kansas title standards? Because clearly they followed all the steps in the title standards. And I know that's not law, but.
Your Honor, there are a couple of things. First of all, as the bankruptcy opinion I cited indicates, the Kansas title standards represent the quote consensus of opinion of what title lawyers think is appropriate. But more importantly is there's no evidence in this case as to what the actual practice being followed by title insurance companies is. I know what it is, but since it wasn't introduced in evidence, I didn't put it in my brief. I didn't think that was appropriate.
All right, I have one more question. So at the time Mrs. Hayes signed the redemption right, the property was held by the person who purchased it at the sheriff's sale under the certificate of purchase. Do you agree, Mr. Upford?
Only to the extent that it's a defeasible estate and title is not actually conveyed to the holder of the certificate of purchase until they get a sheriff's deed.
But at the time of the assignment of the right of redemption, Mrs. Hayes only had that right in her bundle of sticks, right to redeem her property.
I believe that is a correct statement, Your Honor.
Right. And so when she assigned that right, she assigned that stick to Mrs. Pruitt, who then had the right to redeem the property.
That is correct, but again, the law is not always logical, Your Honor. And as I've mentioned, all you have to do is read the tax code. But seriously, the other authorities around the United States say title just reverts back to the owner, regardless of whether or not there's an assignment of redemption rights or not. That's
Are
what-
redemption rights and are these all just statutory, or is there a common law? Is there any common law that we could refer to here?
Your Honor, I do know there are states from maybe half a dozen different jurisdictions that are cited in the footnote of the treatise that is cited in our brief, I believe on page 14.
Okay.
So there is some other case law to look at.
Okay. Any other questions of Mr. Ufford?
I don't.
Okay.
Thank you.
Rebuttal? Very interesting case.
Yeah. Thank you, Justice Berger. I guess I would also, just to kind of dovetail on what Mr. Ufford said, there is an equity of redemption, but that's different from what we're dealing with here today. The right of redemption that we're claiming under is the statute, yes, created by 60/24/14. And I don't want to belabor the point too much, but I mean, I think the court needs to take into special consideration the nuance that's provided by our Kansas statute, especially under subchapter H
Sorry, I
here.
don't know what that's doing up for.
Okay. And I
Can't stop it.
The pizza's done.
I'm sorry. I'm just pushing buttons and the sound is off. I'm just gonna have to turn the phone off. All right. Okay, phone's off.
Okay.
Go ahead.
I've been told by a couple of different justices that I had to turn my phone off because mine rang in the courtroom.
Well, mine was turned down, but when I put that timer on, I messed it up somehow. Okay, go ahead.
I can't speak to what other jurisdictions have done, but I can say that, you know, obviously the place we need to start here is looking at 60/24/14, and the assignment subsection specifically states that the assignee shall have the same right of redemption as the defendant owner. I mean, the legislature has clearly indicated, maybe not in the clearest terms, but has clearly indicated that the intent here with the ability to assign a right of redemption is to give the assignee what the defendant landowner who's lost their property interest at foreclosure sale, what they previously held. I think it would.
That's the key to this. What does the statute mean when it says the same right of redemption?
Correct. And while I understand and I appreciate Mr. Ufford, excuse me, his argument that it gives them the ability to collect rents and whatnot. I mean, I think that while that may be the case, the right of redemption itself is something to be exercised. It's not something to, I mean, it's designed to be used in a certain way, and to just say that it's limited to the ability to collect rents and not intended to be exercised by by the assignee, I think that disregards a whole portion. I think it disregards that language in the statute.
But couldn't your client have contracted with Miss Hayes or taken a quitclaim deed or whatever, saying that if I redeem this property, I get the legal title?
Yeah.
That seems like the missing link in all of this. And maybe it's the legislature that missed that link. Maybe it's the courts. Maybe it's title stand. I don't know who, but that seems like the missing link.
Well, and we did. I mean, we came into this case after the motion for summary judgment had been decided, and were asked to kind of clean up on it. And we did. I know our post trial filing are lengthy and include a lot of documentation, but contained within our motion for relief, I believe it's our supplemental motion for new trial, we do include a bunch of contractual documents. One is an ag lease between.
Can we consider that, counsel, if it wasn't considered?
Okay.
I mean,
was it before the court? Yeah. Was it before the district court at the time of the summary judgment?
It wasn't before the court at the time of the summary judgment. It was before the court in the post-trial motion.
I've got a real basic question that I probably should remember what Professor Duncan told me, but maybe you'll remember what Professor Pierce told you. Is the Kansas redemption statute based on a uniform act?
I can't answer that.
I bet we could find that answer, but
Sure,
I was hoping you guys could tell us, and that would make it easier, because then we could try to look at other cases from the uniform that also have adopted the uniform act. I just can't remember.
Yeah.
It's been too long since I went to law school.
Mhm.
Yeah.
Okay. All right. Anything else?
I don't have
Mr.
anything.
Nicolay? Okay. Our policy is to get decisions out within 60 days. That means filed for you to see within 60 days of today. We make that target about 96% of the time. So our hope is you'll get something from us within 60 days. Sometimes it takes a little longer, but that's generally, so I can't guarantee, but I think with this panel, we'll probably have them out within 60 days. So thank you very much. We appreciate your arguments. A very interesting case. It is one of first impression. We are concerned about making sure we get it right. So thank you for your arguments. They've helped tremendously.
Yeah, thank you both.
Thank you.